May it please the court, your honors. My name is David Popper, and I'd like to put away 5 minutes for rebuttal time, Judge.
Very good.
Thank you. We're here today as my client had been involved in an automobile accident on 10/9 of 2013. It's important to know that about 10 months later he had a second automobile accident, and that will be apparent as I go through my argument. The trial court, lower court, erred in striking Dr. Douglas Price as the witness in this case. They also struck him as the person who could come in and authenticate his medical records. To start with, it was Judge Wolf that had stated that because the defendant at that time up in the appellate could not find Dr. Price, that he could not testify. And they only made one actual effort and one legitimate attempt to locate him, and that was at his prior address where he was living. And at that time in his life, he had gone through some issues where he was also, I guess he was arrested by the FBI, and there was issues of whether or not he was patient brokering. He had, at some point in time, he did end up turning in his license in a diversion program. So at that time, they went to both of his other attorneys to try to locate him. And according to 48031, that is not a proper way to be able to serve someone or to find them in this manner. So they only had one.
If I recall correctly, your side got an affidavit from Dr. Price, correct?
Yes.
Did your side provide the address where he could be served to the other side?
Correct, we did.
And how did you do that?
I did that via phone conference.
Is there anything in the record that establishes this?
I don't believe so, Judge.
Okay, so as far as the record shows, you didn't do that.
As far as the record shows, the only thing that they did was one reasonable attempt at a house he used to live at, and then he went through his attorneys on 2 separate occasions to try to get him at that point, which of course, according to 48031, that doesn't count. There's only one attempt that's been made to locate him at that point. So Judge Wolf at that time said that he's not to come in, he cannot be a witness, we're going to strike him as a witness. At that time...
What's the standard of review on a trial court doing that?
Well, I'm not, as far as I knew, I think there had to be 3 reasonable attempts before a trial court.
What case are you citing for that?
I do not have a case law in front of me.
Okay.
And I know that one attempt is not reasonable. I'm sure of that. I've seen case law, and I wish I had it at the top of my head. I do not. I'll have to.
I feel like I'm back on the trial bench.
But, you know, I mean, they made one reasonable attempt, and that was it. After that one reasonable attempt...
So let me repeat my question, because I don't think you gave me an answer. What's the standard of review when a judge doesn't allow testimony? What's the judge's ability to get reversed when the judge does something like you're complaining about today?
I'm saying when they don't make a reasonable attempt.
Yeah, but isn't it abuse of discretion? The judge
This is
has
a,
a
this
certain
whole...
amount of discretion.
It is an abuse of discretion.
Okay. I mean, if there was a rule of law, and it was 3 strikes and you're out, that we could count the 3 strikes.
Correct,
and that would
Judge.
be a rule of law, so
Correct.
we could reverse on a legal basis. But abuse of discretion is a pretty thick bar to get through. It's not a thin bar like a legal issue. That's why I'm trying to follow your argument.
Yes, my argument has been abuse of discretion on all 3 of my issues I'm going to bring up.
Very good, thank you.
I apologize for any misunderstanding, Judge.
No problem.
Okay, so at that time, we also had a change in judges, and what happened was Judge Cook took over. I went back to Judge Cook and I said I would like to have an evidentiary hearing, which is in the record, which she denied on me bringing in Dr. Price to her so that we could say, look, Dr. Price is available, we have him, he will do his deposition, he will be available for trial. She said no, at this time she would not revisit that. She would not have an evidentiary hearing, and at that time she also mentioned that because Dr. Price had been arrested and because he was charged with brokering, she said he is completely unreliable. She used a wide brush and stroked him as an unreliable witness who should not be allowed to come in to testify as a witness or to testify.
Was there any evidence provided to the contrary? That your client's case was not in part of that investigation?
No, because we can't prove a negative. There was nothing there. My client had never been investigated.
You could prove what cases were involved, and by process of elimination, your client would not have been on that list.
She did ask she did ask me directly if my client was involved, and I told her no, he was not involved in that situation. That's the only evidence I have for that. She basically said that he cannot testify. Now, this type of wholesale exclusion is an abuse of discretion. We have people that come up in front of us who are felons, and they're allowed to testify. We have people that have committed dishonest acts, which are misdemeanors, which are allowed to sit and testify. And I believe that unless you've been ruled incompetent, anyone should have the right to come in and give testimony. It goes to the weight and not the admissibility of such. And in this particular case, the jury could have very easily been able to find out whether or not Dr. Price was as a credible witness and made a determination on that basis. My client was not afforded that opportunity, and he was the one that doesn't get the fair trial because Dr. Price could not be in there. If, in fact, Dr. Price was guilty of the things he was charged with, which I don't know, and we do not have anything to do with Dr. Price, nor does my client now falls victim to being another Dr. Price issue because he did not know. Not only did he not know, he was never investigated in this particular case. Either way, it goes to weight, not admissibility. The jury has that determination. The jury should always have that determination. That's why we go to court. That's why we have trials, because everyone should be able to be heard. And Dr. Price, by not being able to be heard, caused a huge problem in our case. And let me explain. It was critical that we had Dr. Price come in, because from the very opening statement that I had to make was, you will not be hearing from a doctor. Well, you won't be seeing his records either, but you'll have to trust us. He did treat for a year, and there are medical records someplace out there. It was foolish. It didn't look right. It was a bad situation from the very go. There was nothing else I could do. I didn't feel I could do any type of an appeal in the middle of this, and I had to get this trial under our belts, hoping that one day we could satisfy the DCA, because I felt that was the only opportunity we'd get a fair shake, was getting Dr. Price the opportunity to come back at a second trial. The evidence was, the jury had to determine this, because without Dr. Price and this critical evidence, we had no doctor to be able to come out and determine. We had one accident. He treated him after this first accident. There was a second minor accident, which he treated him before and after that accident. There was no other doctor that treated him at that point. So therefore, I had only one way of proving causation, and that was with Dr. Price. With Dr. Price now stricken and his record stricken, it didn't give me much of a chance to prove causation. And let's consider the fact that they already admitted liability. I had a road that was pretty easy with causation of damages. I couldn't hold that road because I had nobody to come in to testify for that. They had to rely on statements from their expert. They had to rely on my second doctor who saw him, and for the most part didn't see him before or after that accident, so it kind of left a little bit of a causation gap. The only causation gap that could have been stopped was Dr. Price. He knew this patient. He knew him before he knew him after the first accident. He knew him before the second accident, after the second accident. He was not allowed to come in. He was not allowed to discuss those issues, and that type of exclusion really put my client in a position where we cannot prove causation, and it's directly related to that. They also erred in having Dr. Jack Maniscalco come to testify. My law partner, Stan Geip, had been doing the questioning on him, and he had a situation where when my client now has been excluded, his records have been excluded, but yet they hire an expert that comes in and says, I read Dr.
Yeah, but he made it clear he didn't rely on those. He made it really clear that he did not rely on that particular doctor's records. He went through and analyzed what he relied on, and it was clear it was not that.
That was a semantical argument, I believe, Judge, because the question was, do those records of Dr. Price's have a bearing on these opinions?
Well, he said exactly that. They had no bearing on his opinion.
Well,
he reviewed them, didn't have any bearing in his opinion. Isn't that what he said exactly verbatim?
he actually said yes after he said, do those opinions have a bearing upon his opinions? He said yes, because they did have a bearing. They may not have been the actual records that he relied upon, if we're going to use a different word, but let's look at it this way.
Well, he said he relied on the records of Dr. Ransom.
Yes.
Coming to the conclusion that Martinez reported he was free of pain after the October 2013 accident.
Yes.
He reported that in January 2014.
The problem with that is when you have a doctor like Dr. Maniscalco who does these CMEs, these IMEs on a regular basis, by reading and having the opportunity to see all of Dr. Price's records, and then he gets to make his decision, clearly there's going to be bias here, which I tried to prove.
So the question is, they were going to present this video testimony of Maniscalco. Is that your complaint, that they did it by video, or that you didn't have him under subpoena where you could have cross-examined him differently?
No, I don't believe he should have come at all. I think he was tainted by even looking at Dr. Price's records and then coming back with saying that his opinions had some bearing on that, considering we knew that he was going to be saying the exact opposite. This gave him a perfect opportunity to see what Dr. Price would have said and what his records said, and completely contradict that in straight testimony, knowing that Dr. Price wasn't going to be able to defend himself.
So it was your motion to exclude the video that is your complaint here?
Yes.
Okay, thank you.
Yes. And the next issue that had popped up, which I believe the lower court erred in, was there was a Dr. Hammond. When that second accident occurred, my client hired a second attorney and he went to a different doctor. Dr. Hammond was now his treating physician as well for the second accident. Dr. Hammond had his deposition taken. Dr. Hammond was given all the documents and information he would need to show that the second accident that he was treating for there was an injury, he was being treated for it. However, counsel had left out a very important document, and it was the report from the MRI. So when I was sitting there, I said, "Doctor," when it was my turn to cross-examination, I said, "Doctor," I said, "wouldn't it be important for you to see all the medical records, not just the ones that you've seen?" He said, "Well, if there's more, yes." I said, "Well, let me show you this document." I showed him the document, and I said, "Would this document change your opinion on whether or not there was a more serious incident?"
That MRI report came from a set of unidentified medical records?
It came from a record that identified as an MRI that was taken at a particular MRI center and read by a particular radiologist, but that was it. And the dates on it were very, very evident. He said, yes, it would change his opinion. It had to change his opinion because it was the truth. The truth was the first accident caused all of his injuries.
But the MRI was never admitted into evidence.
The MRI?
The objection was lack of foundation, speculation, hearsay.
Yes.
And there was no response to address those concerns.
Well, first of all, the motions in limine were held a month before trial was supposed to begin, and there was no mention of this. They never mentioned a motion in limine or any type of motion to keep out my cross-examination. So
Martinez indicated he was going to call Dr. Hammond as a live witness, but never did so. Is that correct?
We never called Dr. Martinez because we agreed to play his video, which included my cross-examination. But once the judge struck my cross-examination, which really struck the truth of the whole matter and would have certainly changed the opinion of Dr. Hammond, which he said he would right there in his deposition transcript, it left me with a situation where now I couldn't get Dr. Hammond into the courtroom.
But at the pretrial conference, there was a representation made that that witness was going to be called.
I don't believe it was made to be the witness was going to be called. He was on our witness list. But what we agreed upon was that we were going to play his deposition in its entirety, not chop off my cross-examination, which of course was what turned the doctor's opinion from, yes, it was related all to this second accident, and now he's changed his opinion because he sees how bad the MRI was, and now all of a sudden now I've got a doctor who was going to change his opinion to, no, we don't even get to see that part, so now it's all in the favor of the defense again.
But based upon the objections made during the deposition is why the court limited the testimony of Dr. Hammond, the depo testimony.
And again, I disagree with that ruling because, as I stated in court that day, this was a discovery deposition, and there was no violation of any rights or rules. I clearly laid out the path for him. I showed him that there was a medical record that was missing. I showed him the medical record. I asked him to identify it. He did. And then he said that would change his opinion. So I clearly think at that time it was wrong to be, I think the judge made a mistake as he erred in excluding that. And that's abuse of discretion as well. So now I had a situation where I had no Dr. Price. He couldn't come in and testify. I had no records from Dr. Price. I had a situation with Dr. Hammond, who I had at least to say, yes, it was, the first accident was much more serious and it changed his opinions on things. I got that wiped out to now it's Dr. Hemming goes in there with half documents, so to speak, and now he gives a false presentation of, yes, he believes that it was to the second accident. Now, I think that's misleading to the jury, and I think it's an abuse of discretion to allow that to happen because it confused the jury and it misled them completely. Because how can you have a doctor who's sitting there saying, hey, this is from the second accident. I know they want to prove the first, but I got nothing showing me. I show them the document, the one paperwork, the piece of paper that clearly shows that, yes, this was the first accident, and he's going to change his opinion.
Counsel, you've used 15 minutes of your time if you wish to reserve the 5 for rebuttal.
Yes, I do. But as far as that's concerned, I believe that that was also an abuse of discretion by the judge to allow that, because now I have a situation where I've got another doctor who is now actually giving the defense what they want to hear rather than the truth.
Good morning, may it please the court. My name is Anthony Russo. I represent the appellee Ruben Martin. Not attributable to counsel, but there's a lot of there's a web of deceit in this case that comes from the witnesses, and it permeates the case.
Mr. Russo, pull the mic a little closer.
Certainly. Let me start, issue one, Mr. Price, not Dr. Price. Mr. Price, the beginning and the end of consideration of that issue starts with that he could not be found. He was listed on 3 or 4 different witness lists with an address. He was never found at that address. We went to his former lawyers in the criminal side. They said they didn't.
Who was the attorney who provided the affidavit from Dr. Price?
Opposing counsel today.
So let me ask you a hypothetical question. Does that, on its face, mean they had access to that witness?
I would assume so, yes.
And they never provided you a better address than what your process
We
server
never had a better address. We never had a correct address.
And he made several
He eventually
attempts.
resurfaced, right?
Excuse me?
He eventually resurfaced.
With the affidavit?
No, well, I mean, his whereabouts became known at some point prior to the trial.
Not to us.
Okay,
Not that I'm aware of.
okay.
If it's in the record, I missed it, but
Okay.
I do not believe that's correct.
Well, he was under investigation. He was charged. Eventually, the charges were dropped because he gave up his license.
Yes.
Okay.
So he could not have testified as an expert, or would have been heavily impeached on that point.
Mr. Russo, counsel indicated that at one of the hearings before Judge Cook, there was an offer to make Dr. Price available for appearance before the court. I'm not finding that in the record, or did that, does the record establish that? I should have asked opposing counsel that, but I was trying to find it.
Dr. Price or Dr. Hammond?
Dr. Price.
I'm not familiar that offer was made, and I don't know if that's in the record, and perhaps opposing
There's
counsel.
nothing to confirm or deny.
Pardon me?
You can't point to anything in the record that confirms or denies that.
That's correct. I
Requested
cannot
by
do that,
Judge
right.
Silverman, okay.
Yes.
In the transcript of, if I recall, there were 2 hearings in front of Judge Cook on this issue, and it doesn't appear that in those transcripts there's any indication that Dr. Price is prepared to come in to make a proffer or to give a deposition.
No, I have not seen that, Your Honor. I can't say that, no. So that's the beginning and the end of the Dr. Price issue. We never get into anything else. If he won't show up to be deposed, he can't testify at trial, and he can't testify as a records custodian, because we did not waive records custodian. We needed somebody to authenticate Mr. Martinez's records, because they do have the stench of fraud on them, given the affidavits of the detectives and the indictment and all of the circumstances under the Rule of Evidence 608 that says it's not trustworthy, then you have to have a records custodian, and we never got one. But because he couldn't be found, that's the beginning and the end of Dr. Price. As to Dr. Maniscalco, the record, part of the record that I see, page 897, is that he reviewed the records. And maybe there's something else that says more, but when he's asked, are you aware of the October accident? Yes. Where did you get that knowledge from? I reviewed records. I gleaned it from a review of the records. That's page 897, line 19. He never said he relied on them. And as Judge Cook noted at the trial, he rejected them. As to issue 3, I think there's a misunderstanding about Dr. Hammond's, how that evidence played out. And if I can just walk the court through a couple dates, I'll explain what our position is. Dr. Hammond was deposed in May of 2016. The record's at 12/21. He was asked the questions by trial counsel, Mr. Ramey, what's your opinion? Dr. Hammond said, well, he presented to me, Mr. Martinez presented to me, and he told me about this second accident, and he laid all the blame on the second accident. And then Mr. Ramey ceases his direct examination. It goes to cross-examination, and that's when Mr. Papa says, well, did you ever see this MRI report? Objection, speculation, foundation, hearsay, and we have the series of objections. Now, soon after that, Mr. Ramey, defense counsel, files at page 1320 objections to the deposition questions that were asked on cross-examination. And he puts them in the file. That's 2 years before trial. So plaintiff's counsel's on notice, hey, we're going to object to these series of questions you asked on cross-examination of Dr. Hammond. Go down the line 2 years later at a pretrial conference. The parties submit a filled-out pretrial order to Judge Cook, which you can find in the record at page 580 and at page 590. Rather, you'll find question 16 where the questioner says, do you have objections to deposition testimony to be read? And Mr. Ramey puts in defendant's objection to deposition of Kenneth Hammond, D.C. So we're intending to make those deposition objections at the pretrial conference, and that transcript is in the trial, in the record, at page 1417. Judge Cook is going down the pretrial order with counsel saying, well, I see at page 1421, you have objections to the deposition testimony which is to be read, she asks. And Mr. Ramey says, I think you've already heard these, but may be reserved ruling because I think Mr. Papa may intend to bring this witness live. This is Dr. Hammond. He's going to bring him live. He's saying this at the pretrial conference a week before trial. Mr. Papa, I do. I'll lay the proper foundation which you've requested when we had the hearing. We're talking about a hearing a year ago. Mr. Ramey, so that would be moot. The court, that's moot. And when you go back to the pretrial order at page 590, question 16, you'll see Judge Cook wrote in there moot because at pretrial he said, I'll bring Dr. Hammond live. Well, he didn't bring Dr. Hammond live.
And the purpose of bringing Dr. Hammond live was to cure the foundational problem by this unidentified MRI coming into evidence.
Yeah, foundation, speculation, and hearsay, and to deal with those.
But Dr. Hammond may have been able to cure that had he been called live and spoken beyond what was in the deposition.
Debatable, would say no,
I'm
he'd
just
say
saying
yes,
that's the
we'll
only way.
never know. I'm sorry, Judge.
Right, but had Hammond been called live, they could have opened the gate to that possibility, but by not opening the gate, you had no chance of getting that in evidence because it was a valid objection when it was made.
And that's what Judge Cook said exactly in the transcript. She said, at the deposition, that's a well-taken objection, and it's sustained. And now in their case in chief, they brought plaintiff's case in chief, Dr. David Rosenbach, who read the MRI. They called Mr. Martinez, who presumably said that this was all due to the first accident. And they brought Dr. James Ronzo, who did some surgery. And I suppose if he could have proved causation, it would have been in the record, included in the record on appeal. It's not. The trial transcript isn't with us. So there's nothing much can be said about that. It was Mr. Ramey, defense counsel, who brought who had Dr. Hammond's deposition, and that's when the court had the chance to rule. And that's in the trial transcript, and the judge said, as you noted, when this deposition was taken, it was speculation, there was no foundation, and there's hearsay. And that's a trial decision, and it's reviewed under abuse of discretion. And for all those reasons, the trial judge didn't abuse it, the verdict was good, the judgment should stand.
Thank you.
Judge, to clarify, I believe counsel is correct, and certainly I didn't mean to mislead anyone as far as the conference that we had and the conversation we had about Dr. Hammond. I do believe, again, I've made a proper foundation on that. I believe it was abuse of discretion to make that decision, especially at that time.
There's nothing that precludes a court from considering objections to some deposition testimony at the time the deposition testimony is going to be used at trial, correct?
That's correct.
And nobody waived the objections ahead of time?
No, no. And again, what I did was I believe that the actual foundation was laid down properly, and it was a discovery deposition, and in its entirety, it should have come in. So that was my argument for abuse of discretion on that issue. Overall, I would just like to say that it's the real issue I think that we have a problem with that we can't get past is we all agree that Dr. Price was stricken, and the bottom line there is when I asked for an evidentiary hearing,
Counsel, where did you ask for the evidentiary hearing on the record? Because I'm looking at the transcripts and I don't see that.
it was in one of, I believe we were in chambers with the judge, and I asked for an evidentiary hearing.
Is there any transcript of that?
I thought it was in the transcript.
Okay, can you point me to it? Because in looking at the transcripts, I didn't see that.
I cannot at this time. I cannot, and I don't believe it was in my my brief as well. It's just from my memory, so it's not evidence that I can produce.
Well, if it's not in the record, it didn't happen.
Okay.
So at what time was Dr. Price finally located?
We found Dr. Price within, it had to be 6 months after the ruling from Dr. Wolf, to Judge Wolf.
Okay. So, and you found him and you made him available to the other side, say, we found him if you'd like to
I
depose
did.
him,
I
here he is."
I made a phone conference call.
Is that in our record anywhere?
I don't believe it's in the record.
Okay, I'm sorry I asked it then.
Yeah.
Because it's not,
But he was
just
avail-
like Judge Shorman said,
Yeah,
it's
no,
not
I
in our
get it.
record, it didn't
Yeah,
happen.
he was certainly available. There's no evidence that shows he was available. I proffered him at trial.
That's actually the entire problem with Dr. Price. What in the record demonstrates that he was made available or was available for the other side to depose him?
Well, they only made one attempt. I mean, you know.
But you've indicated that you contacted him or located him, you got an affidavit from him.
Yes.
So what in the record demonstrates that there was an offer to fix this problem, which goes to Judge Volante's issue of, well, the standard of review is abuse of discretion. So what establishes in this record that the trial court abused its discretion in continuing with the same ruling that Judge Wolf made?
Only that they did not make any other attempt than make one attempt to try to find this doctor who was out there, obviously. And, I mean, they went to his...
Obviously, but it took you based on what you've indicated, it took you 6 months to find him.
No, we weren't searching for him. We came across... Well, it's not in evidence. I'm not sure I should even talk about it, so...
If there's nothing in the
No,
record,
what it is that they made
He
one
also
attempt
didn't
only.
show to a deposition though, right? Deposition was scheduled, he did not appear. Is that right?
I don't remember that, him not showing up at deposition, nor did I remember that being in the
Well, it's in
record.
the briefs, so somebody
I don't remember him
remembered
not
it.
showing up at deposition. If that was the time he had been arrested, he might have been in jail at that time. I don't know. But I do know that they made one attempt to try to find him, and that was it. So it's not like it was a situation where he could not be found. I don't think they really looked for him, and I don't think they made any attempt other than that one time. I don't think that when you go to somebody's attorneys and you say, hey, we need to get this guy, I don't think that's something that can be included, and I already mentioned the rule against that. Other than that, I thank you for your time, and I would appreciate it if you would give my client what I would consider a fair trial and have the opportunity for the doctor to be a witness and the doctor to be able to come in with his paperwork and testify.
Very good. Thank you very much, counsel.